thank everybody for joining us. I'm CLIA's Executive Director, Mary Trosco. It's my pleasure to welcome you to tonight's presentation on youth criminal justice with our presenter, Candace Olson. We acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and it's the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake 40 First Nation. Now, a little bit about our presenter. Candace graduated from the University of Manitoba in 2009 with a degree in history and sociology, and completed a second degree in criminology and native studies in 2010. She attended the University of North Dakota for her first year of law before transferring to the University of Manitoba to complete her degree, graduating in 2013. Candace received her call to the bar in 2014 and practices primarily in the area of criminal law at the firm of Smith, Corona, Van Dongen, and Cook. Prior to joining Smith, Corona, Van Dongen, and Cook, she articled for Brodsky and Company and worked for several years at Martin White Manning Newman. Candace's practice includes working on a variety of criminal charges for both youth and adult accused, ranging from property offenses, violent offenses, sexual offenses, impaired driving, drug and weapons offenses, and homicide. She also assists with quasi-criminal matters and in the area of child protection. Candace is a member of the Criminal Defense Lawyers Association of Manitoba and has served as a board member for McDonald Youth Services for the past several years. Prior to attending law school, she also worked as a youth care practitioner with McDonald Youth Services. So I'll turn over to Candace. Thank you very much for joining us.
Thank you, Mary. All right, so as Mary kind of laid out, I am a defense lawyer practicing here in Winnipeg. And so during this presentation on youth and the justice system, I'm planning to just do a broad overview to basically go over some of the key concepts. And I do understand that people joining us today do come from a variety of different agencies. So I'm happy to answer questions as they come up and certainly provide more information depending on what people are looking for information on. So feel free to use the Q&A. I think we were talking before we got started here, and I don't have access to the chat, but I do have access to the Q&A. So feel free to put some questions in there as we go along or at the end, and I'll answer them. I'll try and monitor that as well. So the work that I do with youth in conflict with the law really is part of my favorite work. It really allows and encourages for a more intersectional approach in the youth justice system or in the justice system. And there are usually a multitude of issues that are being dealt with. And there's resources that are able to be connected with, that type of thing, that allows us to try and address underlying causes of offending in youth in a way that engages all of the supports that they have, and in a lot of ways isn't really accessible in the same way in the adult system. It's also built into the legislation to really give the court powers to ensure that that type of intersectional approach happens, which is obviously beneficial. So we see things like conferences for bails or sentencings, forensic reports requiring CFS to intervene in some cases, or mandating attendance of certain people as things that the court has power to do, which certainly help to ensure that when youth are going through the justice system, they're getting access to all of the different supports and resources available in the community. And really that's done because the goals for the youth justice system are different than the adult system. In the youth justice system, there are, and I mean throughout the adult system as well, but a lot of the issues we see can include family breakdown, parental neglect, and struggles that people are going through at that time, addictions issues, parenting skills, having some issues there, poverty, and of course, our incredibly long history of colonialism, the impacts and destruction that the residential school system has caused for Indigenous people in our community. And all of that plays into affecting children's behavior. Peer groups can kind of play into behavior as well. And those things can impact on their involvement in the youth criminal justice system. But even in those cases, there are sometimes the youth system can help address some of those underlying issues before it's too late and we see them reoffending once they're in the adult stages. So in terms of the presentation, I hope everybody can see my screen. What I've planned to do is I've kind of broken things down into 5 different parts. There we go. And we're going to talk first about the principles underlying the legislation. We'll move next into rights to counsel for youth and how there are some differences in comparison to the adult system. We'll talk about extrajudicial measures. We'll talk about bail, and then finally we'll talk about sentencing for youth. Before I get started on those aspects, I do think it's important to comment with respect to some context of who, especially in Manitoba, is being dealt with under these systems, under the youth criminal justice system. And the reality is that in Manitoba, we are seeing that there is a trend in a relationship between child welfare involvement with youth and simultaneous youth justice involvement. And we also know that the vast majority of youth in custody often live with mental health issues, cognitive disabilities, dealing with trauma, an abundance of different issues that are affecting them. And we also are very much aware that there's an overrepresentation of Indigenous youth in both systems, the child welfare system as well as the youth justice system. And that's something I wanted to essentially point out and make sure people are aware of. And there was just recently, I published in the spring of 2020 by our government, a study about the crossover kids, and it's about that intersection between the child welfare system as well as the youth justice system. So I have the links here. I can provide them as well after if people want to take a look. There's a summary of the report as well as the full comprehensive report as well, which certainly, again, like I said, provides some context as to who is being seen in higher numbers and overrepresented in the justice system as well as the child welfare system. In terms of some of the information from that report, it was done by the Manitoba Centre for Health Policy at the U of M for Manitoba Health. And really what it shows is that there is a relationship between having been in CFS care as well as being charged with a crime as a youth. And the study was able to kind of quantify the overlap of the two. But it does make clear that there is not a causal link between the two. But some of the important findings were that youth who had ever been in care were 5 times more likely to be charged with a crime than a youth that had never been in care. And so certainly there is a link there and some association. And they conclude that being in care was one of the strongest associations, more than sex, being in an urban versus a rural setting, family income, any of those aspects to being charged with a crime as a youth. So we'll kind of shift into a discussion first about the principles underlying the legislation. When I'm talking about the legislation, I'm talking about the Youth Criminal Justice Act. So the main legislation that governs youth who come into conflict with the law is the Youth Criminal Justice Act. So we'll talk throughout this section about what that is, what the goals of the YCJA are. And the YCJA is essentially the body of law that governs what should happen to youth who commit criminal offenses. The YCJA works in unison with the criminal code, which of course gives us the legislation for dealing with adult offenders in Canada. But the YCJA doesn't itself cover every single aspect of the law for youth, and where there are aspects where it doesn't specifically address an area, then of course you would have to look to the criminal code to get the answers. But the YCJA is based on different principles and that kind of underlie that legislation and different foundations. And so there need to be modifications and in terms of when you're using the criminal code. And so that's important as well to keep in mind. So for instance, one thing that you'll find in the criminal code that you won't find in the Youth Criminal Justice Act is every single crime and the elements that make that up. That's not laid out in the YCJA. If you have a specific crime, assault, theft, that type of thing, you're not going to find that in the youth legislation. Instead, you'll look to the criminal code. And same goes with respect to like sentencing, for example, the available sentences for adult offenders will be in the criminal code, but you don't utilize those for youth offenders. So who does the YCJA apply to? And the easy answer to that is young people between the ages of 12 and 17. If you're over 18, you fall under the adult justice system, so the criminal code. And if you're under 17, when you are under 18, 17 and under when you've committed an offense, but say perhaps now you're 18 when you're arrested and going through the system, you're still going to be under the YCJA. So it's about when the offense happened. And so why is there a separate legal regime for youth? And the reality for this is that it's based on the principle of diminished moral blameworthiness. And so there was a case, and I've cited it here for you guys, RVDB, that came out in 2008 that really kind of clarified that. But essentially, it's the presumption in law that as a consequence of youth's age, including that during that period of time, there is a heightened vulnerability, they're immature, and there is a reduced capacity for moral judgment, that they then have a reduced culpability for their actions. And so that's why there is this separate legal regime for youth versus adults. So let's talk a little bit about the history of youth law and the history of the legislation. So that's the YCJA. That first came into effect in April of 2003. Even prior to that act coming into force, though, youth have been treated differently from adults for a very long time. Prior to the YCJA being the legislation, the Young Offenders Act was in place. And then prior to that, it was what was referred to as the Juvenile Delinquents Act. And that the JDA came into effect in 1908. That was one of our first ones. And that stayed in effect until 1984. That's when the Young Offenders Act came into play. Of course, there's amendments throughout the years that stayed in effect until 2003, when we have our current legislation come into place. Throughout the years, essentially what was recognized is that there needed to be changes, and the YCJA was born from that. So the YCJA has been in place since 2003, but there have been changes throughout that time. One of the most significant sets of changes came in 2012 under the Safe Streets and Communities Act. And this was essentially an omnibus bill that addressed a number of different things. Specific to this conversation is that it made a number of changes to our youth justice system. And it really was designed to strengthen the way in which serious, violent, and repeat youth offenders were being dealt with. So now, after these amendments in 2012 through that act, protection of the public is a highlighted principle of our youth justice system. In Canada, and many other countries as well, our laws do treat youth differently from adults, and that's been a long accepted thing. Certainly, there's been for a long time, there's been a difference between how we treat adults versus youth, and an acknowledgement that the criminal code should not be effective for youth. And there's a number of different reasons that we do have those separate legal and sentencing regimes for youth who commit crimes. When we look at youth, they come into conflict with the law for a vast number of reasons, as do all people. But for youth, oftentimes we see that this really is a time of experimentation, rebellion, maturing. They test boundaries. They're dealing with peer pressure, for instance. And the YCJA does, in some respects, allow us to treat youth offenders differently with that immaturity in mind when it's appropriate, focus on rehabilitation to avoid re-involvement of youth in the justice system going forward. And it does that by acknowledging and recognizing that diminished moral blameworthiness. So we'll talk now about the foundations of the legislation, or the guiding principles. One of the things in terms of that is that, kind of in a response to what had been under prior legislations, this lack of clear and coherent youth justice philosophy, the YCJA really was set out and is based on a number of different guiding principles. One of the first ones is society's responsibility to address young persons' challenges and help guide them to adulthood. So, society has a responsibility to really address those developmental challenges and the different needs that young people have. And the idea here is that prevention of youth crime is not just the work of the courts and legislatures, that the community at large is responsible for helping to curb youth crime. Communities and families should work together in partnership with others to prevent youth crime by addressing those underlying causes, responding to the needs that young people have, and providing them guidance and support. And so programs and resources need to be in place to address the reasons why a young person offends. Do they come from a dysfunctional family? Are they suffering from some kind of disability? Is there an underlying mental health issue? Are addictions issues at play? Has there been abuse experienced? Have they experienced trauma? All of the underlying reasons that a person may become involved with crime need to be addressed and looked at. And the goal, one of the main goals, is to really use that multidisciplinary approach to help prevention of youth crime and respond to the needs. And so it really is kind of that intersectionality that I first started out speaking about. The goal of the YCJA was and is supposed to be a collaborative approach to addressing those underlying causes versus just being a justice system based on plea bargaining and case processing type legal system. And under the formal legislation, the result of that approach really was to produce really high levels, some of the highest levels of youth incarceration in the Western world, a very high recidivism rate. And so it was very clear that approach didn't work. And so in terms of the YCJA, the goals shifted, the principles really shifted. And now these foundations are what are utilized to try and look to rehabilitation and that type of thing. Another foundation is the principle to ensure that accurate information about youth crime in the youth justice system, as well as effective measures, be made publicly available. So there is always pressure on the youth system to impose harsher sentences, despite the fact that we see in research and statistics that course of action really does little to curb youth from offending or reoffending. And we see this response in all crime generally as well, even in the adult system with imposition of mandatory minimum sentences, for example. But this founding principle really becomes important to ensure people are aware of what is effective and what is not, and why it is that certain approaches are taken. Another foundation is that the youth justice system should take into account the interests of victims, ensure accountability through meaningful consequences, rehabilitation, and reintegration. There's also that the youth justice system needs to reserve its most serious interventions for the most serious crimes and reduce the over-reliance on incarceration. So the YCJA really does aim to provide reasonable alternatives to custody. And as a result, custody really is seen as a last resort. And there are specific guidelines on when it can be imposed and when it cannot. And we'll talk more about that in terms of sentencing later on. The YCJA also has a recognition of young people's special guarantees and rights and freedoms as well. In terms of its own declaration of principles, it really is, as I mentioned, one of the focuses now is to protect the public, and it kind of strives to do so by holding young people accountable through measures that are proportionate to the seriousness of the offense and the degree of responsibility of the young person. You really have to look at the individual circumstances of each case and each young person. One of the other ways that you kind of go about ensuring protection of the public is by promoting rehabilitation and reintegration of young people back into the community. So rehabilitation, focusing on getting them help with whatever issues may be plaguing them, whatever underlying causes there are, and then reintegration, ensuring that when they are back in the community, that there's a smooth transition in that rejoining. Another aspect is supporting crime prevention, and this is really done by referring young people to programs or agencies in the community to address circumstances underlying their offending behavior. So there is the principle that, of course, the young people should be separate from the adult system. And in terms of kind of what we're focusing on, it really is that emphasis on rehabilitation and reintegration, fair and proportionate accountability that's consistent with greater dependency of young people kind of in the community. They're dependent on adults for their well-being, of course, and they have that reduced level of maturity as well. They have enhanced procedural protections that ensure their rights to privacy are protected as well. There is, in terms of other kind of core focuses, there is a need for timely interventions, and that's something very important in the youth system, is this need that there has to be a timely intervention so that there is this reinforcement between behavior and consequence. And it's important, given the different perception of time that young people have. Things really have to be done promptly in order to have a meaningful impact. And courts have looked at this a number of different times and stressed that importance. There, of course, needs to be the ability for the young person to link the consequence that they're receiving with the behavior. And in order to ensure that's happening, it has to happen quickly. So all of the interventions that kind of go through are really meant to ensure that there is a respect for society's values, ensuring that there is a reparation of different harms done, that there is this meaningful consequence, something that actually the youth can take an understanding of what that consequence means and why it's being put in place for them. All of this has to be done in a way that is respectful, of course, to gender, ethnic background, cultural background, linguistic differences. It has to be done in a way that responds to Indigenous young people, as well as people with special requirements or special or any special needs of any sort. And so again, that really does focus on that individualized response that takes into account not only the offending behavior of the young person, but their background and what's required for that particular young person as well. And so kind of in terms of the justice system itself, the YCJA, there are mechanisms in place in the legislation itself to help identify appropriate resources, for example, because one of the founding principles is that we need to focus on this multidisciplinary approach, ensuring that we're addressing those underlying causes of youth crime. So one example of something in the legislation is what's called a forensics report, and that's in section 34 of the YCJA, which allows the court to order a report for a youth, and that's not really possible in the same way in the adult system at all, unless you're going to do so privately at your own cost, which certainly would be quite an excessive cost and out of reach for a lot of adult offenders as well. And so this really is one of the biggest benefits sometimes to the youth system and the difference between the two systems. And this type of report basically allows for a medical or psychological report to be compiled that can look at physical or mental illness or disorder, psychological disorders, emotional disturbances, whether there's a learning disability, a mental disability, that type of thing, so that there can be more information gained to ensure that going forward, appropriate resources, appropriate connections are being made for rehabilitation for that young person and ensuring they get that assistance. It also gives recommendations for the appropriate intervention. So it's really an extremely helpful tool, especially when you look at what the purposes of the YCJA are, what the purposes of the youth criminal justice system are really trying, what the goals are and what they're trying to achieve there. Under section 35 of the YCJA, there's also the ability for a judge to make a CFS referral, which can be helpful, and to have them intervene or at least become involved to see if any intervention is needed. And so these guiding principles allow for an approach to youth involved with crime that really is distinct from the adult system. There's that focus on meaningful consequences, things that need to happen in a timely manner and take into account the individual needs for the young person and engage the larger community in assisting to basically try and help rehabilitate young people and have them rejoin society in an effort to stop criminal reinvolvement. For many youth, the interventions available as part of the youth justice system are extremely valuable because of those underlying principles that the YCJA is based on, and that multidisciplinary approach that is to be taken. It provides the justice system with a number of different options for interventions, really based on that individual person, which certainly can be incredibly helpful. So we talked through those. We went through some of these here. My apologies, I didn't go through my slides, but I can certainly send them out so that people can look at them as well. Now, next we're going to talk about the right to counsel. Essentially with the right to counsel, when a youth is detained on, arrested, or charged with a criminal offense, the YCJA, again, is the legislation that applies. It sets out how that youth is supposed to be dealt with, what their rights are, what the obligations of the police are, the court system obligations, and what they need to do in dealing with them as well. One of the most important things is the right to counsel. So upon detention or arrest, and there is a distinction between detention and arrest, but just quickly, basically arrested, you're going to be told you're under arrest. With a detention, as soon as a young person is stopped by the police and is basically not free to leave, they're being held in some way, then they have the right to counsel, just as any adult being arrested or detained would as well. But for youth, there are additional rights with respect to the right to counsel that come into play, and additional obligations on the police and the courts as well that need to be complied with. So you have the right to counsel without delay. So immediately upon arrest or detention, a young person needs to be told that they have the right to access counsel. For people that deal with youth, it's important to know that a lot of youth won't know a specific lawyer's name. Maybe it's the first time that they're being arrested and they've never dealt with this before, but there is always counsel available through the legal aid system, 24/7, 365 days a year, whether you know a lawyer's name or not. There is the availability of counsel, and youth are able to access that, as are adults. And so they need to be told immediately that they have this right to contact counsel without delay. And that also means that they have to be given an opportunity to do that in private, to be able to get the information that they need and the assistance that they need. So in terms of police officers, the police officer in charge also has some further obligations aside from just telling them that they have this right and coordinating a private phone call. The police officer arresting a youth also needs to notify the parent or guardian of the arrest, the reason for the arrest, the place where the young person is being held. So that information needs to be passed on to their parent or guardian as well. The youth needs to be informed of the reasons for their detention as well. So it's not only just, okay, you can call a lawyer, it's why are they being arrested, so that they can actually get proper advice from their lawyer as well. Now, the police have obligations more than just to say, here are your rights, right? Or I called the parent and they're aware. The police have to explain the right to counsel really in a language that the youth is going to understand, right? We're dealing with young people, some as young as 12, who may not understand the language that often gets used in legal settings in the same way that an adult would. So it needs to be provided in plain language so that they're understanding that. For people that English may not be their first language, certainly if there is a barrier there, they also have access to counsel with a translator available. And again, there are services available so that translation can be provided for a youth if they need that. And that's something important depending on where people are working and what interactions you may have with youth. It's important that they're aware of that as well. Courts and review boards also have some obligations with respect to the right to counsel. They have to advise the youth of that right at different stages of the proceeding and ensure that they know that they do have the right to be represented by a lawyer as well, not just get that free legal advice upon their initial arrest or detention, but also have the opportunity to have a lawyer represent them throughout the court process as well. They do have a right to be represented by a lawyer on their matters in court and not just a chance to get that initial advice at the police station. And so there are obligations at every stage of the proceedings that they're informed of their right to retain counsel, as well as instruct counsel. And they also have this right, and we'll talk more about this later on, they have the right to get access to counsel before or during any consideration on whether an extrajudicial sanction is going to be used. And so we'll talk more about that in later in the presentation. If legal aid will not provide a lawyer, or parents are unable or unwilling to pay for a lawyer for a youth, there is the ability under the Youth Criminal Justice Act, Section 25, and that basically allows a court to order that a lawyer be appointed to a youth. So again, they always have a chance to get a lawyer, not the same with the adult system at all. If you can't afford a lawyer or you can't qualify under the legal aid system, then unfortunately a lot of adults are left to try and figure out how they're going to either represent themselves or get access to counsel. That's not the case with youth. There is also the availability to allow an adult who would be deemed suitable, so it's something that would need to be appropriate in the circumstances, to assist a youth in dealing with their charges if that's what they'd prefer as well. Part and parcel of kind of your initial rights upon arrest, kind of going along with this right to counsel, is also the right to silence. Young people, just as adults do, have the right to remain silent, the right not to make a statement anytime that they're stopped or questioned by the police or arrested by the police. So certainly it depends on the circumstances, but there are certain instances where perhaps a little information might be required. They don't necessarily have to say anything to the police, but oftentimes it's hard to know whether or not you're required to provide your identity or identify themselves. Most times it's likely going to be difficult to tell if the police have the right to ask you for that or not. If you're being pulled over under the Highway Traffic Act, asked to give your license and registration, you have to do it. Most oftentimes you're not going to know, so you're safer to just provide your identification. But the right to silence does not mean that they have to talk to the police or answer any of their questions. If a youth does decide to make a statement, then the right to counsel does become extremely important, because for that statement to be admissible down the road, used as evidence, it has to be what's called voluntary. And they need to be told, this young person needs to be told of their right to counsel, the reasons that they were arrested, be able to say, yes, I want a lawyer, or decline wanting a lawyer, say, I don't need that. They have to understand that they're under no obligation to give a statement, that statement really may be used as evidence against them later on. But they must also be given the right to consult with a lawyer and a parent or older adult. An extra right that youth have that adults don't have is that they have the right to have a lawyer and their parent or older adult, guardian, whoever it may be, in the room with them when they're giving a statement. And that's important to know, because it's up to the police to coordinate that as well, and not the youth. And that becomes important because oftentimes people get arrested at very odd hours, the middle of the night, right, during the day when maybe their parents are at work or something like that. But if they wish to exercise their right to have a lawyer and or a parent present, it can be both or either, when they make a statement, then the police have to wait and they have to try and facilitate that. Adults do not have the ability to have a lawyer or anybody else in the room with them, present with them when they make a statement. So again, this is a very specific right, particular to youth only. But of course, just as adults are, youth are allowed to waive the right to counsel. And so if they decide they don't want to have a lawyer, they don't want to speak to a lawyer, they don't want to have a lawyer present with them, they can make that choice. But oftentimes it will need to be recorded. It will need to be done on video, audio, or sometimes in writing as well. If they waive their right, the police then can try to continue and try and get them to make a statement without anyone present. And so it's important that they know what their rights are before making that decision and knowing the availability as well. Because I mean, obviously, the right to silence and the right to counsel are very important for youth to know about. They're important for adults as well, but specifically for youth, what happens with the police really can shape how a matter does proceed through the court. And it's important for youth to know what their rights are, be able to use them, and just obviously take into account that they are more immature. They obviously might not have the same knowledge of the justice system as adults may. A lot of times youth are also going to have a different reaction to somebody in such a position of power, the police, trying to get them to speak as well. So it is important to ensure that they know that as well. The next thing we'll talk about is what's called judicial interim release, or bail. And so bail is just the common term. Judicial interim release is the more formal term. You'll hear it kind of referred to by both. But when a young person, a youth, is arrested and held in custody on an offense, they do have the right to apply for release or bail. And just like any adult would. Again, they have a lot of the same rights as adults would, but just as in other aspects, there are slight differences that are in the youth system that aren't in the adults. Youth have the right to apply for bail only to be detained where the Crown can show cause that their detention is necessary. And that's different because in the adult system, there are certain times where it's on the kind of the burden shifts, and it's actually up to the accused person to show that they should be released rather than the Crown to show that they shouldn't. But that's never the case in the youth system. In the youth system, it's always on the Crown. It's their onus to bear. It's their burden to show that the youth should be kept in custody. And under the YCJA, this is kind of referring back to what we said before when we're talking about only having having people in custody for under specific instances and trying to limit that in as many ways as possible. With respect to bail or judicial interim release for youth, you really can only keep youth in custody if it's a serious offense or if there's a pattern of outstanding charges, findings of guilt. So they've shown a pattern of not complying with the law in the past. So for example, you have somebody charged for the very first time with a shoplifting charge. You're not going to see them detained in custody as a result of that. When we're talking about judicial interim release or bail, there are different grounds for detention or keeping them in custody. They're called the primary ground, the secondary ground, and the tertiary ground. And so the primary ground is just whether or not that young person will come to court to actually deal with their matters. The secondary ground is looking at whether or not detention is needed to protect the public. And so that needs to look at the risk to public safety, including whether there's what's called a substantial likelihood that the accused or the accused youth will commit a serious offense. And that's of course different from the adult test. The adult test looks at whether there's just a substantial risk to public safety. There's also the tertiary ground, and that really is looking at whether it's necessary to keep somebody in custody to maintain confidence in the administration of justice when they're charged with a serious offense. And so in these types of situations, you're really looking at exceptional circumstances type cases. You have to look at a number of different factors. It's not going to be every case, and it really is going to be where it's a serious type of offense. Now, in deciding bail, the court basically has to look at whether or not there's any conditions that they can tell the youth that they would have to follow to satisfy them that they can be released. So making sure that they appear in court, making sure that there is that adequate protection of the public through some kind of conditions, maybe a curfew, or making sure that they're not hanging out with certain people, that type of thing, and maintaining confidence in the system. Unlike with the adult system, the YCJA used to specifically state that if the offense was something that would not result in jail, then there was this presumption against pretrial detention or keeping them in custody before they deal with their matters. But in 2012, the amendments that we talked about earlier did change the YCJA again. So now there is no presumption against pretrial detention if there's no potential for custody. A young person may simply kind of in terms of the process, once they're arrested by police, they may simply receive a summons or what's called an appearance notice. And then they would just be released from custody after the allegations, after the police have completed processing them. A summons is basically a notice that a young person has been charged with an offense. It will also contain that requirement that they appear in court on a specific date and time as well. So not every youth that gets arrested is going to have to go through this formal process of applying for bail. Some will be released by consent, some will be released just by the police. One important thing that has to be looked at in terms of the youth justice system is that pretrial detention is prohibited when being used as a social measure, and that's under Section 29. So you're not allowed to use jail as a substitute for appropriate child protection, mental health services, social services. That's not acceptable. And unfortunately, there's kind of complicated issues that arise sometimes in dealing with youth. And certainly there have been kind of cases in the past where there haven't been appropriate placements in the community, there haven't been appropriate or sufficient supports in the community to help deal with some of the underlying issues that young people were dealing with. And there had been this reliance on kind of leaving them in custody because there was nowhere else for them to go. The YCJA specifically indicates that that is not acceptable and that cannot be done. So if there's not appropriate housing, only shelters available, that's unfortunately not, or that's fortunately not going to be a reason that you're allowed to keep somebody in custody. And so those situations really require social service interventions, not criminal justice ones. And we see this kind of intertwined. Sometimes there needs to be, in terms of figuring out what works, those extra reports, whether it's a forensic report, like we talked about, a referral to CFS, that type of thing, they can be helpful to ensure that we are setting people up in the community as well. And not just having people in custody because we can't figure out what's going on. Getting those answers as to what's appropriate, what interventions they need. Now, youth also have what's available to them, what's called a responsible person application. So if a young person goes for bail or asks for release from custody, and it's determined that they pose too much of a risk, that they won't follow their court orders, that they might not come to court, or that the confidence in the justice system wouldn't be maintained if they were released, then they'll be denied bail. And that means that they have to stay in custody. So if a youth is denied bail, then they can be released to a responsible person. So it's a second application that would essentially be made. And again, this is different from the adult system. There is not an option for this in the adult system whatsoever. What this application is, it essentially places the young person in care of that responsible person. And the responsible person is required that basically they have to undertake in writing to be able to care for that young person. The young person has to be able to confirm that they think that they'd be agreeable to this situation as well. And they have responsibilities. They have to ensure that that person attends court, that they comply with any conditions that the court might put them on. And so it really is a situation where a young person would otherwise be kept in custody. Now that responsible person comes up and basically says that they're willing to take over and assume care and control over that young person and enter into that arrangement. A lot of times we see youth engaged, as I kind of started out at the beginning, outlining, we see youth engaged in CFS or under orders from Child and Family Services. CFS doesn't usually agree to be a responsible person, so it's not every youth that's even going to have this available to them. But essentially what would happen if there was this person available is that another hearing would be had. The person kind of offering themselves up to be this person would be examined and provide evidence to the lawyers, the court, or the judge, answer the questions of them. And basically the test is whether or not they can assume that care and control. And if they are taking on that responsibility, it's not just a promise to the court, there's actual liabilities, including up to jail time if they're not succeeding or not taking their role seriously. I'm going to move on now to extrajudicial measures. So what are they? They're basically a way of dealing with matters outside of the traditional justice system. A review of prior youth legislation found that there was this over-reliance on incarceration by the courts, like we talked about, and that courts were overused for minor cases that could be dealt with better outside of the courts. So the YCJA provides for these EJM or extrajudicial measures as an effective way of dealing with most youth offenses. And it really allows for both police and Crown to deal with youth outside that formal justice or court system for minor charges, things like shopliftings or mischiefs, that type of thing. And it really gives the Crown and police that discretion, but it gives only the Crown and police that discretion. So it's up to them to decide if this is going to be the avenue that's taken when a youth is charged. And if they decide not, a judge can't overrule that and say, we'll send them to extrajudicial measures. It's up to them. So as we were saying, there is this presumption against custody built into the YCJA. And that presumption is overtly expressed in the act itself, but it's also reinforced in this particular section as well. And so there is this presumption that nonviolent first offenders are going to be diverted or taken out of the traditional court system. And that's set out in section 4C, and it provides for these extrajudicial measures. And they are presumed to be adequate, to be enough to hold a young person accountable for their offending behavior if the young person has committed a nonviolent offense and has not previously been found guilty of offense. So they have no record, it's their first time getting charged. Sending them through these processes is, in the legislation itself, deemed to be enough, adequate to have that meaningful consequence for them and hold them accountable. It also kind of takes into account that the process in and of itself can be a sufficient consequence for youth. Sometimes just being arrested and having to go through the scary nature of that is enough to hold them accountable for their actions, and it takes that into account in some ways. So for example, imagine you have a 12-year-old who's dealing with the police and being arrested for the first time. I think it would be natural to be worried that their parents are going to find out about it, about them being arrested. They're, I'm sure, worried that they may have to go to court. They're in trouble now. Their parents will have to come with them. All of the different things that could possibly happen. That is an anxiety, anxious situation in and of itself, and can be very stressful, can be very scary for young people. And the YCJA really recognizes that those steps, those processes are a meaningful consequence in and of itself. And that really is the whole goal, is provide meaningful consequences, hold kids accountable for offending behavior, but also promoting rehabilitation and reintegration, of course. And so kind of keeping it in mind, that overarching principle of protecting public safety as well. But these are adequate measures, and there's a number of different things that can be used. I'll just do this here. The first is that no further action can be taken. So that's just what it sounds like, that the police can decide that they're not going to go any further with that. There is the ability to have a warning. This is a more informal type thing, where basically both the Crown or the police can give a caution or a warning. Police, before laying a charge, must actually consider whether it would be sufficient to take no further action, to give a warning, to give a police caution, or to refer that person to a community program. So they have that obligation to be able to put their mind, or to have to put their minds to that, on whether the extrajudicial measures in and of themselves would be sufficient. If the young person is charged, then the Crown may give a formal caution to the young person, and that's a Crown caution. So the warning is more an informal thing, warning them not to kind of participate in this again. The caution is more of a formal thing, and certainly there's the Crown caution that would basically be the more formalized way to basically say they're not going to proceed with court proceedings on this occasion, but they can go one step further and refer the youth to a different community agency, and have them access different programming, maybe do some community service work, that type of thing. There's also the availability of what are called extrajudicial sanctions. And these are really the most formal type of extrajudicial measures. And they're only to be used as a last resort if the warnings, cautions aren't adequate, and only if the province has a program in place as well. We do have a number of options in place here. So there's the availability to do counseling, programming, community service work, maybe some of the different sanctions used. Extrajudicial sanctions would only be used where it's appropriate, given the nature and the seriousness of the offense. So it still has to be an offense for which that would be appropriate. You're not going to be sending an aggravated assault type matter through this type of process. In order to participate with the extrajudicial sanctions, there has to be an acknowledgement of the offense. And so basically the young person has to take responsibility for the allegation being made against them. And so when we talk about this, we have to go back to that right to counsel that we talked about and we discussed earlier, because a youth that's being offered this extrajudicial sanction has the right to counsel before and during that decision on whether that avenue is going to be taken. And that's extremely important, obviously, because there is that requirement to take responsibility. So they need to ensure that they have that right to counsel, that they're fully informed when making that decision as well. It's important to kind of know that extrajudicial sanctions and measures are not going to be used and not supposed to be used where it's a weak case, the evidence isn't very strong against the person. It's not going to be used in serious offenses where the community would be at risk, things like the aggravated assault, sexual offenses, things where gang activity might be alleged, that type of thing. So there, again, you have to look at the particulars of the offense itself. And so then you would, in order to qualify, you would have to admit that offense. You'd have to agree to participate in the program, whichever one you're being referred to. If you deny the offense, or you just simply want to go through the justice system in the more formal manner, then you can't be considered for that program, and you're not going to go through that avenue. You're going to then be referred to the justice system. But if you do get the ability to be referred to one of these measures, or one of the different sanctions, if the youth successfully completes whatever was required of them, then the charge isn't proceeded with. If they're unsuccessful, then their participation in the extrajudicial sanctions, any comments or admissions that they might have made, can't be used against them. So that's obviously beneficial, but it would go back into the regular court system and still have to be dealt with in the more traditional manner. If they're referred to extrajudicial sanctions and are later charged with other offenses, their last participation can be used in a finding on whether or not there is a pattern, which impacts on what type of sentence would be available as well. And we'll talk more about that when we get into sentencing. So, sentencing, when extrajudicial measures or sanctions are deemed not to be appropriate, and a youth pleads guilty or is convicted after a trial, a number of sentencing options are available. And so when deciding how to sentence a young person, the court really must follow the purposes and principles of sentencing as set out in the Youth Criminal Justice Act. And these really connect back to those overall purposes of the YCJA as a whole that we talked about at the beginning. The goal really is to protect the public while you're holding the young person accountable, you're using sanctions that have a meaningful consequence, and you're promoting rehabilitation and reintegration. And so principles that the court has to follow when they're crafting a sentence include that the sentence cannot be greater than a sentence that an adult charged with the same crime in similar circumstances would receive. And so that's important because that acknowledges that presumption that youth do have a diminished moral blameworthiness in comparison with adults. Another important principle that the court has to look at is the principle of parity, and that has to be taken into account. And that is the idea that similar sentences for offenses committed in similar circumstances need to be imposed. Proportionality is another principle the court has to utilize when crafting a sentence, and that's the idea that the sentence has to be in line with the seriousness of the offense as well as the background of the young person. And that really kind of relates back to the idea that this is an individualized process. You need to look at the person you're dealing with, not just the offense itself. If it's reasonable to do so, then custody should not be imposed, looking at that as a last resort only. Particular attention has to be placed on youth with Indigenous ancestry, given, of course, the long history of colonial impacts from residential school systems, as well as other systems within Canada that have long impacted our Indigenous populations. The least restrictive sentence that can be put in place should be imposed. The sentence that is most likely to achieve rehabilitation and reintegration, which of course are one of those overarching principles, needs to be imposed. And the sentence really needs to promote that responsibility for the young person, as well as an acknowledgement of the harm that was caused by their behavior. Oh, I think. Okay, I see a Q&A here. Are GLADU reports used in relation to youth? That's a great question. Yes. So for anybody who doesn't necessarily know what a GLADU report is, it's what we commonly refer to in the justice system as, it's essentially a report that looks at Indigenous people's background. It looks at their personal circumstances, whether or not their family was impacted by residential schools, what their family background is, what their connection to culture is, all of those types of things that really do impact on them as a result of colonialism. What we have the ability to do in our court system is order a formal report. These are often done in our court system through probation services, but you do have the ability to get one privately if you wish. But a court-ordered report would come through probation services, and they would interview the youth, they would interview their supports, whether that's family members, social workers, any other collaterals that they would have access to, and they would talk about their particular background and kind of what different issues might be present with them, and specifically how have they been impacted by colonialism in their family. And so those are available. They are a great sentencing tool to give that context, give that individualized information to the judge, because one of those core principles is to ensure that you are keeping into account, of course, this particular the particular background of Indigenous people in our country. So yes, they are available, and in the same way adults would have them available as well. So in terms of kind of other sentencing principles, specific deterrence and denunciation have been added to the YCJA, but they're still not to use what's called general deterrence. So general deterrence is using a sentence to send a message to the public at large that this behavior can't be accepted. So imposing a sentence on a young person can take into account ensuring that you send a message to them specifically that if they repeat this behavior, it won't be accepted. That's specific deterrence. Denunciation is just denouncing their conduct, saying that it is not appropriate. General deterrence is that we also need to tell society that you can't do this. That's not something to really be taken into account for youth. And so this process really does center on balancing all of these principles to craft a sentence that is appropriate. So if extrajudicial measures are not appropriate, then the YCGA states that custody is not the next step. And essentially, in fact, it should not be resorted to except in certain cases. And those specific circumstances are set out in section 39 and 40 of the Act. And we should essentially be looking at non-custodial options first to see if they would be appropriate, using custody only as that last resort. So one of the overall goals of the YCGA was to reduce the overuse of custody as a bail or sentencing option. And again, that's expressed a number of ways in the Act, through extrajudicial measures and in terms of sentencing as well, having that presumption against custody, like I said. So there are a bunch of different types of sentences, but generally for youth, sentences fall in two categories: custodial, non-custodial. So in terms of what sentences are available in a non-custodial aspect, there are a number of different options available. So judges can impose on a youth who has either pled guilty or been found guilty after a trial, and they have all the same rights with respect to trial as an adult would. And the ability to ensure that the Crown proves any allegation against them in that way. But if they have went to trial, and we're looking at a sentencing situation now, the judge can do something like reprimand them. They can impose what's called an absolute discharge. So after hearing all of the information, they discharge the conviction. And that would essentially end the matter. They can also impose what's called a conditional discharge, and that would be very similar to a probation order type situation where they would get a list of conditions, a period of time that would go for, and if they successfully follow those conditions and live up to the obligations under that conditional discharge, at the end of it, their conviction would be just discharged or taken off of their record, as long as they are able to live up to those conditions. They can impose fines up to $1,000. They can also impose a sentence that compensates for any loss or damage that may have resulted as a result of their offenses. There can be compensation by way of personal services. They can impose community service work with a maximum of 240 hours. And so there's a number of different opportunities for community service work to be done in our communities. And that can be done all by itself. You can also have the imposition of a probation order, so a period where the youth is on probation, again, following conditions. Sometimes it can be supervised, sometimes it can be unsupervised. Supervised would be kind of working with probation services, ensuring that they're getting access to different resources, kind of guiding them through that process and reporting and that type of thing. Unsupervised would just be, they're not reporting on a regular basis to probation services, but they're still bound by those conditions to ensure that that rehabilitation is focused on. They can, judges as a non-custodial sentencing option can require attendance at a non-residential program, so sending them to programs to participate in as well. The other side of that are custodial sentences, and committal to custody really is, as I think I've said time and time again throughout this, seen as a last resort, and it really is only available in certain circumstances. If the offense is a violent offense, then offenses that endanger life and safety of another by creating that substantial likelihood of causing bodily harm, that's what would be deemed a violent offense. That would open the door to custody. If there were previous non-custodial sentences that were not complied with, that can open the door to allowing a judge to impose a custodial sentence for an offense. It's important with this, though, that it has to be more than one prior sentence, that non-custodial sentence that wasn't complied with. So your very first breach of a probation order or a probation order or one probation order that you're breaching isn't going to open up the availability for the next time that you breach to allow for a custodial sentence. If the offense is an indictable offense for which an adult in the adult system could receive a sentence of 2 years of jail, and that youth has a pattern of findings of guilt, so they have a record, or you can take into account that extrajudicial measures or extrajudicial sanctions as of 2012, that can lead into that finding that there is this pattern as well, and that can open the door. In exceptional cases, so where there's a young person who's committed an indictable offense, where the aggravating circumstances really are such that imposing a non-custodial sentence would be inconsistent with the principles that we talked about of sentencing, then there are those exceptional cases where a custodial sentence can be put in place. In terms of custodial sentences and how they really play out, the reality is that every period of custody has to be followed by a period of supervision in the community. And the rationale behind that is that supervision is going to allow for better reintegration after being released. So you're looking at a gradual transition, essentially being the goal with that. The period of supervision in the community will have young people bound by a set of conditions that they have to follow. If they don't, they can be rearrested and they can face consequences for that as well. And so there is this kind of breakdown of any sentence where you're going to serve part of it in custody and a part of it under supervision in the community. So there's different types of custodial sentences. It's not just one type where you're just in custody and that's the end of it. The kind of one first level of custodial sentence is what's called a deferred custody order. And this is a jail sentence, but it's served in the community. That's only available if the youth is charged and convicted and found and not found to have caused or attempted to cause serious bodily harm. And so in certain facts, even though the offense itself may mean that they might be open to getting a deferred sentence, if there is serious bodily harm, then that would preclude them from this. But what a deferred sentence is that it's that jail sentence that you serve in the community. It's usually the first tier for a custodial sentence if the youth doesn't have a record, no prior custody, that type of situation. The maximum length for that type of order is 6 months, and strict conditions are usually in place. And again, if you don't follow them, they can be charged and there will be consequences for that as well. The next level is what's called open custody, and that's the next level on this continuum of custody security. And essentially with open custody, the youth can get leaves from the institution, and these are called reintegration leaves. And you have to essentially work up to these, and it's kind of a sliding scale of freedom, so to speak. But it can be things like permission to leave for certain activities, could be passes to leave for a set period of time, that type of thing. So it opens them up to these short passes, this ability to start their reintegration in a slower manner, and that's leading back to that gradual transition back into the community, so that we're kind of achieving those goals of rehabilitation, reintegration. The next is secure custody, and that's the highest level of custody, and that's reserved essentially for the worst offenders and the worst offenses. You do not get reintegration leaves here. It really is secure, just as it sounds. You're in custody and you stay there for the period. Now, in terms of sentencing, you can have a combination of both open and closed. For example, if a youth is given a custodial sentence of 18 months custody and supervision, it can be broken down into 6 months in closed custody, 6 months in open custody, 6 months in community supervision. Custodial sentences will always have that 2/3, 1/3 split. So 2/3 of the sentence is going to be custodial, whether it's open, closed, or some combination of both. But 1/3 will always have to be in the community under community supervision. And that again is to promote that reintegration. So you're not just having a youth come to the end of their sentence, sending them back out without any gradual transition, and really promoting that reintegration. The other option available is what's called IRCS, or it's Intensive Rehabilitation Custody and Supervision Order. And if they qualify, the young person is essentially committed into a continuous period of intensive rehabilitation for what would have been the custodial portion of their sentence. That's not available in all circumstances, and yeah, it essentially is just a more intensive rehabilitation focus. So here are the different lists there. And now we'll talk a little bit about adult sentences. In certain cases, the Crown can make an application for a youth to be subject to an adult sentence. After the 2012 amendments, now the Crown does have to consider an adult sentence for youth who are 14 and over, who are charged with murder, manslaughter, or aggravated sexual assault. The Crown has to advise the court if they aren't applying in those situations. In other cases, the Crown can still seek an adult situation, but they must give notice to the youth, and usually through their lawyer, prior to any of the pleas being entered, prior to the youth deciding whether they're going to plead guilty or not guilty for the offense they're charged with. The offense does still have to be an indictable offense for which an adult would be liable to 2 years more if they were sentenced. If the Crown doesn't give notice that they're seeking an adult sentence, then the court cannot impose one. The burden really is on the Crown to show to the court that an adult sentence would be appropriate in the circumstances under which they're asking for it. So there would be a separate hearing for that application. Essentially what the Crown would have to show is that diminished moral blameworthiness, that it's not present, and that imposing a youth sentence in that particular circumstance would not be sufficient. Other than for murders, the maximum sentence a youth can receive is a 3-year custodial sentence going forward. The judge could also take into account any time they may have spent in custody before that, which could lengthen that, but going forward, the maximum is a 3-year custody order. So in certain circumstances, the Crown may look at this when the facts are very serious, or it's clear they think that there is no diminished moral blameworthiness, and so they could make this application, and then essentially the youth would be sentenced as if they were in the adult court. Other considerations that kind of take place in the youth justice system are things such as placement. This is basically kind of where young offenders are housed. So if you're under 18, the YCJA says that you have to be housed separately from adults. So you'll find yourself in the youth center here in Manitoba. That's usually the Manitoba Youth Center or Agassiz Youth Center. After you're 18, there can be an application made for a transfer for you to be taken to an adult facility, and that's based on what's best for the youth, if there's any risk posed to other young people as well. In that situation, the youth does have an opportunity to respond and basically put their position out there. After age 20, placement on whether or not they're in an adult facility or a youth facility would be up to the provincial director. Of course, if we're talking about somebody who is charged after they're 18, they're going to end up in an adult facility. This is specifically for youth that have youth charges in the youth system and then either serving their sentence or still dealing with their sentences as they progress in age. So those are different considerations that the court has to take into account as well. And so with that, that's what I've outlined for us to discuss today. If there's any other questions, I'm certainly open to answering them.
Well, it doesn't look like there are, but maybe we can wait a couple of minutes.
Yeah.
Just in case someone has a question. We're still got some time.
Sure.
Okay, no one wants to talk today? All right. Oh, there's a question.
We have, in your experience, are youth rehabilitated? Well, I mean, every case is different. Obviously, the approach for individualized sentencing, individualized approaches throughout the system is for a reason. Everybody's dealing with different issues. Everybody's situation is different. I think with respect to the tools available in the youth justice system, there certainly is a lot more available to help with rehabilitation. And that really is because of that multidisciplinary approach, right? And so the whole goal is rehabilitation. And there's going to be people where the involvement, and I've seen this in my experience, the involvement, the interactions that they have, the resources that they're able to get in touch with because of their early involvement are going to help them do well and succeed going forward. And you may never see them after they've been charged and in the youth system and they go on to do great things. And of course, there's going to be people who unfortunately do continue to reoffend and become involved even as adults. But I mean, it's kind of the same way with the adult system. Are adults rehabilitated? In some cases, yes. In some cases, they continue to offend. But the reality is that there really is a lot more open and available, and a lot more avenues to allow the court to really get that involvement from different community resources for youth, which is great.
Okay, anybody else? Good questions. Okay, going once, going twice.
Feel free to ask anything.
That's right. Now's your chance.
Is there a feeling that courts want to support children and the ethics of the Youth Justice Act or not? Yeah, like I think in appearing in front of these courts, certainly the judges that are appearing in youth court are very knowledgeable on what the goals are, and they ensure that they're working within that. And the real goal is to do that rehabilitation. So I don't. I mean, they're bound to follow it. So unless I'm kind of missing something, but yeah, they're there to support the rehabilitation. But they also have, like, it's this balancing act, right? Protection of the public, deterrence, denunciation. The court does still have to take that into account. So it can't just be the focus only on rehabilitation and reintegration. Unfortunately, there is that kind of delicate balance that they have to put into place and make sure that all of the things that we've talked about, rehabilitation, reintegration, general or specific deterrence, making sure you're sending those messages, making sure they're being held accountable, and as well respecting victims' rights and that type of thing throughout the whole process. So it is a delicate balance.
Okay.
Good questions, guys.
That's right. If we just give them a bit more time, they'll ask more questions, I think.
Yeah.
Or maybe not. Okay.
One thing that I'll just add that I realized I kind of glossed over at the beginning is in terms of things that are available to the court. We talked about these forensic reports and we talked about this multidisciplinary approach. And I talked just briefly about the availability of conferences for bails and sentencings. Basically what a conference is they can be judicially attended or not. So one where a judge sits down with a group of people, or one where there's no judge involved, but it allows for, in coming to those decisions on bail, whether or not somebody's released or what the appropriate sentence is, it allows for a number of people, whether it's the parents, resources in the community, social workers, any other people that have some kind of interest in engaging, to really sit down. Basically what happens is you sit down in a room and you talk out the different issues. So-and-so is struggling with this specific thing. And as a result, it's leading to this type of behavior. How can we address that and kind of get everybody who's involved to figure out solutions on what may work? And it also gives the youth a voice as well to talk about maybe why they're doing these things or what their feelings are on that, and what their engagement will be. So those are really, really important as well, to help guide where things can go.
There's also a question in the chat. How does the charter work with the YCJA?
Okay, so the charter applies to youth under the YCJA just as it applies to adults. So everybody has the same rights under the charter. So for instance, the right to counsel, that is a charter right. Youth get some extra benefits on that in terms of having their counsel allowed to be present with them, that type of thing. But they have the same privileges under the charter as every other person in Canada.
Any other questions in the chat or in the Q&A? Okay, well, it's getting a little painful, so maybe we'll call it a night.
That's fine.
Thank you very, very much, Candace, for a great presentation. Candace has done presentations for us in the past, and always a great presentation. Thank you to all of you for attending. Please do fill out the survey. We do really want to hear from you and want to make sure our webinars are the absolute best they can be. Next week's presentation is going to be on welfare law with Jennifer Unger. It'll be hosted by CLIA's program coordinator, Victoria Weir. And I hope you'll all join us. And I guess we'll now say good night. Thanks a lot, everybody. Good night.
Thank you, everyone,
Thanks,
for your great
Candace.
questions and your time. Take care.
Thanks, Candace.
You're welcome.
Bye, everyone.